Thank you, Mr. Chairman. I rise today to offer an amendment that I know the good lady from Minnesota will like on an issue critical to livestock farmers, not just in my state and district, but across the country. In 2013, the Environmental Protection Agency approached 4 dairies in Washington state about high nitrate levels in nearby wells, suspecting semi-permeable lagoons may be the cause. The dairies entered into a consent decree with EPA to identify and treat the cause if it was, in fact, stemming from the dairies. Disturbingly, an environmental group FOIA'd the information the dairies provided to EPA and used it in a file to file a citizen suit under the Resources Conservation and Recovery Act of 1976, or RCRA, against the dairies. Unfortunately, in early 2014, a federal judge ruled the environmental group, asserting that dissolved nitrates constituted a solid waste under the law and high nitrate levels constituted open dumping. There are a number of problems with this case. However, the biggest one by far is the very law used to file a lawsuit. To be clear, there are a number of laws and regulations, both at the state and the federal level, which apply to nutrient management, such as the Safe Drinking Water Act or the Clean Water Act. The problem is, Congress never intended RCRA to be used to regulate agriculture. In fact, EPA expresses that RCRA does not apply to agricultural waste, including manure and crop residue returned to the soil as fertilizers or soil conditioners. I don't know how you can get much clearer than nutrient management was not intended to be governed under this law. And unfortunately, this ruling has left agriculture producers in a legal gray area trying to figure out exactly how to comply with a law that was not intended to regulate them. All this decision has done is to create a culture of fear and distrust between farmers and regulatory agencies. If you're a good steward and come forward to proactively address problems, all you're doing is making yourself a target for lawsuits. Also, it creates a fear that a judge could capriciously decide that you are subject to a law despite clear intent that a law does not apply to you. Mr. Chairman, farmers rely on the law for being clean and want to be good environmental stewards, and this self-defeating culture is not one we want to cultivate. Mr. Chairman, my amendment does nothing to prevent EPA from enforcing current regulations under RCRA. It does nothing to prevent EPA from issuing or enforcing Clean Water Act or Safe Drinking Water Act rules. All my amendment does is prevent EPA from issuing and expanding new regulations under RCRA that would reflect this poor interpretation of current law. While I'm not aware of the desire by EPA to do this, unfortunately, there have been a number of other recent legal precedents directing EPA to take actions they didn't want to take. This amendment will ensure EPA's current regulations stand until Congress has the ability to weigh in and reassert its intent. Mr. Chairman, no one is saying livestock producers, like all Americans, do not share in the responsibility of good environmental stewardship. They certainly do. But there already exist appropriate laws and regulations intended to govern these activities, and there are ones that are not intended to. We as members of Congress have a responsibility to make that clarification, which is what my amendment takes steps to do, and I reserve the balance of my time.